Good morning and good afternoon to our speakers and participants. Stanford International Arbitration Association is pleased to host today's webinar, which is the second of two panel discussions on interim measures in international arbitration. Today, our four esteemed speakers will discuss the following topics: pre-tribunal emergency relief in international commercial arbitration, emergent relief in arbitration as compared with court-issued relief, expedited formation of the tribunal, and comparative analysis of institutional rules on emergency relief and expedited procedures. This discussion will be moderated by myself, Andrii Chornous, President of the Stanford International Arbitration Association. Our first speaker today that I want to introduce is Paul Pietro. Paul is counsel at ICC International Court of Arbitration, New York. In his role, Paul leads the case management team and oversees cases with links to North America. Based in New York City, he administers a constant caseload of over 180 pending arbitrations. Paul is qualified in Venezuela, and he specializes in international commercial arbitration. Paul joined ICC in 2015 as deputy counsel in Latin America, Spain, and Portugal. Paul studied law in Venezuela, Spain, and France, and clerked with prominent international arbitration law firms in Paris, Geneva, and London. He speaks English, French, and Spanish. Our second speaker today is Anna Lombardía. Works as international case director for the ICDR Division of the AAA. Anna's workload is mostly focused on international commercial cases with connections to Latin America and Southern United States. She routinely monitors and administers international arbitrations in Spanish and English. Before joining ICDR AAA in 2018, she practiced as civil litigator and arbitration counsel in Spain. She's admitted to practice in New York and Madrid, and she pursued her LLM in international arbitration at the University of Miami. Anna is also a co-chair of Young Practitioners Group of the Spain and Ibero-American Arbitration Club. So welcome, Anna. Our third speaker is Michael Lampert. Michael serves as an arbitrator, mediator, and law professor. As an arbitrator, he has rendered nearly 50 awards in New York and London. Michael has been a sole arbitrator, a chair, a wing, and an emergency arbitrator for such arbitral institutions as AAA, CPR, LCA, ICDR, and many others. As mediator, he has mediated several dozens of cases, many of which have been settled. For 7 years before turning to full-time dispute resolution, he was Deputy General Counsel of a major financial services company with global responsibility for litigation and arbitration, employment, and IP. For many years, Michael acted as a judge in various moot court competitions. Also, Michael is a fellow of the Chartered Institute of Arbitrators. Our final speaker today is Steven Skulnik, FCIArb. Steven's practice is focused on litigation and arbitration matters. Previously, he was a counsel at Squared Patent Box and a partner at Pavia and Harcourt LLP, while currently he acts as an arbitrator, mediator, and senior legal editor at Practical Law of Thomson Reuters. He has trial experience and appellate experience in many areas, including commercial contracts, art and antiquities, banking, employment, real estate, trade secrets, trademarks, information technology, and different topics. Before we start our webinar, I just want to give a heads up to our participants and ask them to write down their questions to speakers in the Q&A box below, and we'll try to cover them in the end of our webinar today. So, as mentioned during today's webinar, I would like to focus on the concepts of emergency relief and expedited procedures that could be available in international arbitration. So I have a first question to Michael. Mike, could you kick us off by explaining whether in international arbitration there is any substantial difference between such concepts as interim measures and emergency relief? Sorry, you're on mute, Mike.
Thank you, Andrei. Yes, there are very substantial differences. So emergency relief means something that is truly expedited, and there's some variation, but under most rules, one goes to the arbitral institution and says, I have an emergency. Often they will engage in a preliminary analysis of, on the face of it, is there an emergency? If they conclude there is, they will then appoint an emergency arbitrator. Typically, the emergency arbitrator is a single person and who will sit and hear the emergency relief question, render a decision on it. We'll talk more about the form of that decision later, and then become functus officio. And under many of the rules, the emergency arbitrator cannot sit on the ultimate merits panel. unless everybody agrees or there's some other special exception. Whereas interim measures is a merits panel formed in the usual way, making a decision before the final award, earlier than that, on some issue that's needs to be resolved before the full process is completed, but is not in the absolute sense an emergency. And so those are the main differences. There are a couple of important additional factors. So in an unsutrial ad hoc arbitration, because there is no procedure for the expedited appointment of a single arbitrator, emergency relief is not available in an unsutrial ad hoc circumstance. And I thought it might be useful to add an example or two examples. So the ICC rules say that they will in the main try to appoint an emergency arbitrator in 2 days. Parties have 3 days to object, and that once appointed and given the file, an emergency arbitrator has 15 days to render what the ICC rules term an award. So if the ICC process goes as planned, one is looking at roughly 20 days from when the issue is raised to when there's a decision on it. By way of contrast, in an unsutrial ad hoc arbitration I was involved in, the arbitration started in September of 2013. By the time the arbitrators were appointed, we were in April of 2014. One of the parties at that point made a request for interim relief. So 6 months till the request could be made because there was no one to whom to make it. And then the panel took approximately 6 months, and mid-September, that is a year after the arbitration had been started, the panel rendered a decision on the interim relief application. Now, that might seem like a long time, but the final award in that case took 4 years. It took 4 years, 6 years to be rendered, 6 years. So a decision within 1 year on an issue, the interim relief is granted. So there really was some need for a resolution of a particular issue before the final merits. But so those are the differences. Emergency is very quick, and interim is expedited, but not necessarily as quick in terms of who decides.
Thank you, Michael. I see Steven wants to add something, so please, Steven, floor is yours.
A few quick points. In preparing for today, I looked at the UNCITRAL rules, and they actually do have a procedure for emergency arbitrators, but I imagine it's a unicorn because who's going to appoint an emergency arbitrator in 2 days? But you can have an UNCITRAL arbitration where you designate an appointing authority like Anna or Paul, and then it can work. I'm sure they would find the emergency arbitrator as quickly as if they were administering their own cases, and they know that there are certain arbitrators who are no longer with big law firms who can clear conflicts, in an hour. And so that's the advantage of including at least an appointing authority that is as sophisticated as our two co-panelists.
Thank you, Steven. Actually, I have a follow-up question to you. So maybe you and Paul can maybe compare and talk about different approaches of institutional arbitrations and ad hoc arbitrations, and also thresholds when granting an emergency relief. So basically, at what things do arbitrators look under those circumstances?
Well, I can go ahead. Thank you, Andrii. Yeah. And before addressing your question, let me just highlight that the emergency arbitrator provisions are one of the most popular provisions in the arbitration rules of the ICC. And a proof of that is that to date, we have received over 212 emergency applications since these provisions came into force back in 2012. Now, turning to your question, internally at the ICC, we have launched a review of all of these emergency applications administered so far, and I can confirm that there is no universal approach with respect to threshold issues, procedural matters, substantive standards, or post-emergency arbitration considerations. But this is precisely the consequence of the express choice made in the ICC rules to leave to the emergency arbitrator a considerable degree of discretion and flexibility. Of course, it is for the parties to brief arbitrators on the criteria they should consider when deciding these applications. And I would say, at least based on my experience, in most instances, the parties agree more or less on the test. We have even seen arbitrators who consider that they do not need to decide which is the applicable test. And to be honest, at the end, what matters is that arbitrators examine the elements of the test advanced by the parties and decide whether each element of the test has been satisfied. So in order to render, in the order that emergency arbitrators have to render under the ICC rules, the emergency arbitrator has to address the so-called threshold issues. So first, the applicability of the emergency arbitrator provisions, which are set out in Article 29 and Appendix 5 to the ICC Rules of Arbitration. Second, the jurisdiction of the emergency arbitrator pursuant to Article 6.2 of Appendix 5 to the rules. And finally, the admissibility of the requests for emergency measures. Now, more into the substance when deciding whether to grant the relief, I would say that, most emergency arbitrators adopt the standard established by international arbitral practice and consider the following elements. And this is not novel, and I think it's more or less uncontroversial. So first, substantive urgency, beyond the element of urgency as an admissibility hurdle under the ICC rules, requiring that measures cannot await the constitution of the arbitral tribunal. And this is key for both in terms of admissibility and on the substantial aspect. And I have to say that this is some sort of gray area, because many of the emergency arbitrators fail to analyze this element of urgency, both as an admissibility requirement and also as a substantive requirement. Although I have to say that I think that these elements are at the end identical. Another element to consider is prima facie or case or likelihood of success on the merits. Then a tricky one, irreparable or serious harm. And on this issue, I would say there's no uniformity, since some arbitrators follow a literal interpretation of the word or term irreparable, and others instead consider that the harm should be serious and substantial. And part of the discussion boils down to the question of whether harm can be compensated with damages or not. And you have half of the arbitrators supporting the proposition that harm that can be compensated by monetary damages is generally not irreparable. And the other half of the arbitrators just not supporting this proposition. Also, a majority of ICC arbitrators consider necessary for there to be a risk of aggravation of the dispute if the relief is not granted, especially when the relief sought was to maintain the status quo. And this is most of the relief sought we see in the emergency arbitrator applications we have received. And this element in turn is linked to another element, which is the balance of equities. And I checked, and in roughly 20% of the applications, the balance of equity tipping in favor of the moving party was a determinative factor. And finally, the absence of prejudgment on the merits. Very quickly, another issue that arbitrators at the ICC deal with, or let's say approach differently, is that of cost related to this phase of the proceedings. You have some arbitrators on the one hand that do not hesitate to award costs to the prevailing party, whereas other arbitrators prefer to split the baby, so to say, and other arbitrators simply refrain from deciding and just let this issue to be decided by the arbitral tribunal once constituted. And to conclude, part of the takeaways of this review exercise is that regardless of the approaches or the different approaches or the lack of uniformity in terms of, let's say, substantive standard, what is common in all these applications is that only in exceptional cases urgent relief is justified. And I think this shouldn't come as a surprise. Second, voluntary compliance of emergency arbitrator orders is the norm. And finally, it is a fact that emergency arbitrator proceedings are a potential early settlement tool on the merits.
Thank you, Paul. So maybe, Steven, you can contrast it with the ad hoc arbitration environment.
Right. So as we said earlier, the ad hoc emergency arbitrator is really a unicorn. It's going to have to be an appointing authority, and the arbitrator is going to follow the same standard, whether it's uncontrolled arbitration or ICC or ICDR. It's exactly the standard that Paul just described. I would only add that I try also to be practical and minimalist. So I would agree with those arbitrators in the third category who just lets the merits tribunal decide the cost issue. All I want to do is make sure that there's still a live dispute when the merits tribunal is constituted. So if there's a building that's about to be destroyed, or if there's a distribution agreement that's about to be canceled, work with the parties. Sometimes you work with them as almost as a mediator. Well, the supplier is saying, well, he owes me $5 million. I'm not going to ship any more product to him, and the distributor says they have a defense, etc. Well, going forward, fine, put up a letter of credit and keep getting the goods for the next 60 days so that the merits arbitrator can determine whether to continue the injunction or dissolve it, or to say that it can be repaired by damages and allow the termination of the contract. I try to be minimalist to make sure that the merits tribunal still has the case and it's not all mooted out by subsequent events.
Thanks, Steven. As we know, in general, U.S. courts should grant injunctive preliminary relief only where plaintiff has shown like a strong likelihood of success on the merits, where there's a chance of irreparable harm if should relief be denied. The balance of hardship strongly favors the plaintiff, and issuing of injunctions will advance the public interest. But what about requirements for emergency arbitration injunctions at ICDR? So I have a question for Anna. Can you guide us what exactly a party seeking emergency relief at ICDR AAA must demonstrate to prevail in obtaining an injunction?
Sure, thank you. Well, the article in our rules that provide for this particular process of emergency arbitrations is Article 7. And it includes a 4-part requirement for the request to be granted. In my opinion, that article is meant for the institution and for the case managers to assess whether the request has to be processed. Because as Paul indicated when he answered to the previous question, the rules, the ICDR rules in particular, provide a great range of freedom to the emergency arbitrator to decide what standards to apply. What I see is that they tend to apply, or they tend to resort to this same Article 7 for guidance. So they end up including in their reasoning whether or not these 4 requirements have been met. These 4 requirements are first to state the nature of the relief sought. You have to understand that these 4 requirements is for us when we get that request for emergency arbitration to start reading what's going on here, what do they want. So I have to understand the first thing is what these people are expected from us and from the emergency arbitrator. So the nature of the relief sought. Some examples that I would typically see are anti-summary injunctions, injunctive relief, orders for an action to take place, an agreement to be executed. For example, if there's a dispute within a board of directors, some agreements to be executed and implemented. I have a fair deal, a discrete number of cases where foreign companies that have or are planning on suing a government-owned entity for the alleged breach of a concession agreement are being involved in an administrative process for sanctions, and they want that administrative process to be halted. We see, actions to be taken in the context of construction projects to be stopped and to proceed, or for example, in the distribution chain, we see things like that, right? You have to understand that, as Paul indicated as well, the measure should never serve to anticipate the outcome of the main claim pursued in the main arbitration. That would be cheating. That's not the purpose of the emergency arbitration. Therefore, parties need to differentiate very much the different purpose or their goals when they are seeking for an emergency arbitration. The measures typically have to preserve the status quo or to avoid the ongoing dispute between the parties to escalate. The second prong would be the urgency of the measure or the reasons why the such relief is to be granted on an emergency basis. That means that an event must happen immediately or prevent it to taking place to not to impact an ongoing situation. The measure requested needs to be timely and appropriate, proportionate, and because there is an imminent risk of injury or prejudice. This second requirement is very much related with the fourth requirement, which is the injury or prejudice the party will suffer if the measure is not granted. The rule in the Article 7 of the ICDR rules do not provide for more specific guidance as to whether the injury or prejudice has to be substantial or irreparable. But these are typically the criteria that the emergency arbitrators look for. And then there's a third requirement, which is the likelihood to be found to be entitled to such relief. And that, when I was reading that article, you never read things enough times and to find new things. That relief is referred to the emergency measures of protection, not the actual main claim. So it is not necessarily the same as the fumus boni juris criteria that typically the parties use and they claim or invoke in their requests, right? It's for us to assess whether there's some likelihood for this protection to be, for the party to be entitled to that kind of protection. These four criteria, what I've seen in the awards we typically read, the interim awards or the orders we typically read, are applied primarily with other standards to be applied in the second place. But as I said before, in my opinion, emergency arbitrators will also consider the tests and standards raised by the parties and the lex arbitri. Also, I wanted to add there is a fifth criteria I've seen applied and analyzed in the interim award, and is that measure requested and granted is not against the public interest, which is as understood in the international arbitration arena. Okay. I don't know. Regarding the cost, to make a reference to the comments made before by Steven and Paul, I encourage the emergency arbitrators to include in their decisions a reference to the costs. That's a personal preference because I believe they are more familiar with that piece of that section of the process. And down the road, the main tribunal might not be as, aware of what happened in that piece of that during that stage. So I normally, always ask, like, don't you want to make a decision? It is going to be revisited by the tribunal anyway. So it's fine. It's just, but I rarely see it, to be honest. So, yeah.
Thank you, Anna. Actually, I have one tiny follow-up question to you. So you mentioned about this likelihood to be found to be entitled to such relief. And it's really, once I reread it after your words, it's really puzzling. How do you define this likelihood? So what's the measure, what's the threshold of the likelihood, comparing with probability, or maybe you can this.
Yeah, we leave it for the arbitrator to assess, but the analysis we do as case managers is that, well, these seem to be timely and seem to be appropriate, but I cannot anticipate a decision. We are not the ones to make it. It is for us to start the process of going right away and appoint an emergency arbitrator within 1 business days, which is our time frame.
Thank you, Steven. Would you like to add something?
Yeah, thanks. To answer your question directly, most arbitrators, whether the jurisdiction is model law or not, see the model law as the international standard, and that says reasonable possibility of likelihood of success. So that's a definition, and it's basically an objective standard.
Thank you, Steven. Clear with this. So I have a next question to Michael. Mike, how can seeking emergent relief in arbitration be compared and contrasting to seeking one in a court of law? So we heard before the 4 requirements for a general injunction in court. So can you tell more about this?
Yeah, look, I think there are 2 main differences. One is speed and the other is potential effectiveness. So even though the ICC and ICDR have rules that lead to the very rapid appointment of a single arbitrator, that is still a process that takes some time, and parties have to be left some time to protest that there's a conflict by the appointed person. Whereas in most judicial systems, judges serve many-year terms, and in many places, there's more than one judge in the locale, and every jurisdiction I'm acquainted with has a duty judge. And you can, through some court official at the middle of the night, ring up and say, I have a real crisis, I need to see the duty judge. And the judge may not be happy if you wake them up in the middle of the night, but the point is, they're almost always there and available and can be gotten literally in minutes if you had a sufficient justification to do so. Arbitration just cannot do that because it does take time, and there has to be an opportunity for the parties to do that. So the reality is that judicial relief is, if you really have a total crisis, if something's going to happen, and to use the example that Steve did and is fairly familiar of a tree being chopped down in the morning, you can't get an arbitrator in the morning, you can. And a tree being chopped down is not likely to be an arbitration, but one can think of a construction project where there's going to be some alteration to the project that you just learned about. The other important difference, I think, is effectiveness. I know that Paul said, and it is true, that many emergency arbitral decisions are, quote, voluntarily, unquote, complied with by the parties. My sense is that is actually a phenomenon that is in decline, that in fact, more and more parties are willing to ignore what the emergency arbitrator says. And at that point, you have the question of, so now what do you do? If a party is willing to run the risk, and it really is internal to the arbitration system, the only risk is that the ultimate merits panel will be offended that you ignored the emergency or even interim arbitrator's award. If the party is willing to run that risk, what can you do? And the answer is, at that point, you may be able to take what the emergency arbitrator has done, or what is the interim award, and go to the courts. But now you've spent all that time, and it's not so clear. The ICC rules talk about what an emergency arbitrator produces being an order. The New York Convention speaks about awards. And it's not clear on the face of the language of the New York Convention that an emergency arbitrator's order, or even partial award, is enforceable under the convention. More and more courts have been bending the language of the convention and enforcing emergency arbitral decisions, in part because they'd rather have the arbitrators have to deal with it than them. But the reality is there's no guarantee there. To go to the example I used before of the UNCITRAL arbitration, and by the way, Steve, that arbitration was governed by the old UNCITRAL rules. The arbitration actually took place in the year in which the rules were amended to allow for expedited UNCITRAL arbitrations. In that case, the party did choose to ignore. There was an attempt to go back to the courts of their jurisdiction, but for a variety of reasons, they were not excited. And ultimately, the merits panel 6 years later dealt with the fact that their interim decision had been ignored. But even then, the ultimate award had to be enforced pursuant to various New York Convention rules. And in fact, the judicial proceeding to enforce it, remember I said the award came down in 2016, 2019, the ultimate resolution of that case is now pending in the Southern District of New York. There's parties have said they've settled, but they haven't actually done an agreement. So again, enforcement can be much slower, and courts eliminate those problems. If you disobey a court order in most jurisdictions, they send out a person with a gun. And usually that's hard to deal with.
Thank you, Michael. Yes, Steven, please.
I agree with everything Mike said. I would just add a couple of things. Know your jurisdiction. In New York, it's been well settled for 40 years that interim measures by a tribunal can be enforced in court. There's a recent decision, maybe 3 or 4 years ago, from Atlanta, where the judge refused to do it, saying it's not an award. So you have to know your jurisdiction. And then the other thing you need to know is there are certain kinds of remedies that arbitrators can grant, but courts cannot, and certain kinds of remedies that courts can grant, but arbitrators cannot. 2 examples from come to mind. In the Sperry versus Government of Israel case from the 1980s, the arbitrators, that was the merits arbitrator, but they ordered the proceeds of a letter of credit to be put into escrow. A court can't make an order like that. Arbitrators can make freezing injunctions, Moreva injunctions. Courts can't do that, but courts will enforce arbitral awards when they do it. And on the flip side, sometimes you need to put a company or an asset into a temporary receivership. The arbitrator can't appoint a receiver or act as a receiver. The receiver has to be accountable to a public entity, meaning the court. So you have to know what's available and what's not, in addition to all the factors that Mike raised.
I think it's really interesting and practical. Actually, I have one short follow-up question. So I know it's possible to get a temporary restraining order ex parte in litigation. Are there any tools or ways how you can combine obtaining really quick injunction if you have arbitration clause in U.S. courts?
I think you can say, I think a judge would be very open to the fact that I'm seeking emergency arbitrator relief. It will take 3 to 4 days to appoint an arbitrator, and then maybe another 10 to 12 or 15 days to have a decision. I'd like to preserve the status quo for 2 weeks and let me deal with it in arbitration. I think a court would be very receptive to that. If you ask for more relief than that, the court's going to say, why don't you take to the arbitrator?
Yeah, though I think, in fairness, Steve, one has to be careful about that. In the case that I've been referring to, because it was unser trial, one of the parties went to the local courts to seek interim relief. And ultimately, the first question that the unser trial panel had to deal with is undoing a court order granting emergency relief interim relief within the meaning of the unser trial rules. It ultimately decided it was, and that it was empowered to do so, and ultimately entered an order which the prevailing party took back to the courts of that country, and they declined to implement it. They left their prior order in place.
It depends on what the judge said. So I had a case where I was chair where the arbitrator granted a preliminary injunction to last through the arbitration proceeding and up until confirmation of the final award. So there was nothing, we couldn't undo it. But if it's a very temporary relief saying until the arbitrators decide, then the arbitrators can do whatever they like.
Thank you both. It's really insightful and useful, but I would like to turn to the second part of our webinar right now about expedited formation proceedings. So I have a question for Paul. Can you characterize this concept in international arbitration, the concept of expedited formation, and how does it work at ICC, and what requirements do you have?
Sure. So, well, these provisions are relatively new, and at the ICC they are called expedited procedure provisions, EPP in ICC lingo, and they are also a very popular feature of ICC arbitration, especially among North American users. 80% of the cases allocated to my team, the North America case management team, in 2023 were expedited. And these EPP provisions were prompted by the user's desire for, let's say, simplified procedures to be included in our rules. And also it was there's a policy consideration to address the perceived delay in arbitration process. These provisions were conceived and are recommended for cases that do not feature any particular complexity and are of a low to moderate amount in dispute. But here I do have to clarify that we know that sometimes the monetary value of a dispute does not always correlate with its potential complexity. So we can have a case that may not be of millions of dollars, but yet can be very complex, both from the substantial perspective, but also procedurally complex. So for this reason, the decision or the policy consideration at the ICC, and also considering, because you have to bear in mind the wide range of disputes administered by the ICC in terms of geographical region, economic sector, and subject matter, these provisions, the EPP provisions, were included in the rules of 2017, both as a mandatory feature if the requirements are met, and also optional if the parties agree to opt in. And the requirements are mainly two. First, the amount threshold, $2 million or 3 million, depend on the date of conclusion of the contract. And the contract has to be concluded after these provisions came into force, so after March 2017. And if the parties agree to opt in to the application of these provisions to their case, that can be done regardless of the date of conclusion of the contract and regardless of the amount in dispute. So arguably, and we had a $100 million case conducted under the expedited provisions, because the case was, there was only one single discrete issue in dispute, contract interpretation issue. So now perhaps what I wanted to tell you is some things that you should know about EPP. In the first one would be that the ICC court may submit the dispute to a sole arbitrator, and this is notwithstanding any contrary provisions of the arbitration agreement. And this is in order to ensure that the arbitration is conducted in an expeditious and cost-effective manner. And I can guarantee that the court has constantly done so, I would say in 90% of the cases, but with the caveat that if all the parties to the proceedings agree that they want their expedited case to be submitted to a 3-member tribunal, that's also possible. Is not ideal, but it's possible, and we have had and currently have a few cases expedited with a 3-member arbitral tribunal. It also depends on certain jurisdiction. The court has also been hesitant to overturn the parties' agreement to have, let's say, 3 arbitrators and go with 1, depending on the jurisdiction, just to avoid that the future award may be set aside. But other than that, the rule is that they are submitted to a sole arbitrator. Expedited proceedings are expedited, so therefore they are conducted on a fast-track basis, and the award should be rendered within 6 months from the conduct of the case management conference. Of course, since the time limits under the EPP are shorter, parties should be willing to limit the number and length of their submissions. They should be willing to comply with shorter deadlines and potentially forego stages of the process. For example, by agreeing to a documents-only arbitration. But here again, I do want to note that you have to know that in EPP cases, arbitrators have broader powers and discretions in terms of conduct of the arbitration than in the so-called regular track arbitrations. And again, this is to ensure that the arbitration will be concluded as soon as possible and to reduce costs. I would also clarify that it is possible to have most of the features of a full-fledged arbitration in an expedited case. You can have a document production or disclosure phase. You can have a hearing We have seen, again, not ideal, but expedited cases that have been bifurcated into phases for whatever reason. And if the parties agree on a lengthier procedural timetable, you can, of course, have an expedited case that goes beyond the 6-month time limit under the rules. And to conclude, these features, together with the 20% reduction in arbitrators' fees, help to effectively reduce costs. And this takes me to the last comment I have on this, and is that the court has the power, has the authority or discretion to, once the case is in motion and it's conducted under these provisions, to decide to revert and remove the case from the expedited or fast track basis. And this is to avoid a situation in which the parties just have a cheaper arbitration, but actually have a full-fledged, which is, of course, not fair to the arbitrators. Of course, before reaching that decision, the parties are warned, there's a discussion with the arbitrators, with the parties, and then there's a decision from the court.
Thank you, Paul. That was all clear. So as we heard, so in order to activate TPP at ICC, you need to have arbitration agreement concluded after March 1st, 2017, a certain monetary threshold, and no opt-out of the parties to EPP. Let's compare the expedited procedures from ICC with ICDR AAA. So, Anek, how can you contrast them?
Yeah, well, it's the purpose of expedited, the expedited rules is pretty much the same. It's basically to design, to provide for a simplified arbitration procedure designed to reduce the time and cost to be incurred by the parties, right? In our rules, it is a separate section of, you know, a few articles that are meant to be supplemented by the regular track or general arbitration rules. The same as it happens with the ICC, our gating criteria is pretty simple. It is a monetary threshold, the claim amount. In the ICDR rules, that threshold is lower, is $500,000, $500,000 since the last amendments. And for claims below certain thresholds, the rules provide that the decision will be rendered on documents only. You know, there's been, you know, we typically, when we talk about expedited cases or expedited arbitrations, we always mention everybody, and Paul just did mention the fact that a tiny or a small claim amount does not necessarily correlate to a simple case, and that's true. But also the threshold we all use, or, you know, some of us use the monetary or amount in dispute threshold, it is the most practical approach. Because cases with lower claims, there is a limit to the amount of time and money the parties are willing to invest or spend in that case. So it's, in my opinion, it's very understandable from a cost-benefit analysis. Regarding the specific rules for the ICDR, there is this gating criteria. There is the possibility that the parties object to the use of the expedited procedures. And then we will assess if it is, you know, if it is sound so as to remove that case from the expedited track. And the main features of our expedited rules are that the parties are requested to submit their detailed submissions and their proofs at the outset of the case. A change in the amount of the claim or the filing on how to claim won't change the track, will not convert automatically the case into a regular track case. The issue will always be heard by a single arbitrator. Now, in reference to what Paul mentioned, we don't have a court. We don't work that way. In my opinion, where the arbitration clause provides for a 3-member panel, even though the case is being managed under the expedited procedures, I very much refrain from departing from that. So I would typically go with a 3-member panel unless the parties agree otherwise throughout the proceedings. But if the clause is silent and they do not provide for a number of arbitrators specifically, we will appoint a single arbitrator. Now, as to the appointment process, I guess you know that we work with a system that is called the strike and rank list. For expedited cases, the list we provide to the parties, instead of being comprised by 10 or 15 names, it is a 5-name list. And the number of strikes of the arbitrator is limited to 2. So we can guarantee there's going to be a match somewhere where we can appoint someone on an expedited fashion. We build and draft these lists out of our roster of arbitrators. And in our roster of arbitrators, the arbitrators that are willing and available to serve on expedited cases are flagged as such, so that when I do a search to prepare a list, I can identify easily who's willing to serve on an expedited case. Regarding the time frame of the case, as Paul mentioned as well, those are expedited and streamlined procedures. The procedural order, number 1, needs to be rendered 14 days after the appointment of the arbitrator. The hearing must take place 60 days after the rendering of the procedural order. And once the rules provide for a 1-day hearing, and then the award is to be rendered 30 days after the formal closure of the proceedings. The parties can waive, and sometimes they do, to this very, very tight and expedited time frame or deadlines. But typically, when the rules were drafted, the institution was envisioning that the case should not take more than 135 days. I believe is, we see very, very fast cases, but 135 days strikes to me as very, very fast. Sometimes it takes a little bit longer for the parties to appoint the arbitrator, and therefore the case is slightly longer than that. But in general, it is quite fast. Because our threshold is kind of low, if you compare that to other institutions and the general practice in the international field, the percentage of our cases that are managed under the ICDR expedited rules is lower. I was checking not official stats, and it's around 10% of our caseload. The benefits of these rules is that they reduce time to completion. There's a faster resolution. It reduced fees and costs, and there is a limited scope of the discovery. Now, these expedited cases or these expedited procedures represent a series of challenges. And it is that expedited cases are not suitable for all kinds of disputes. If you have a very complex matter or a multi-party case, it is not probably the best fit. If the dispute is highly technical, it is not probably a good idea to get to an expedited track case. And if there's a lack of written evidence on the facts, and there's going to be an intense motion practice or cross-examination of the witnesses and all that, that is probably, these signs make the case less suitable for an expedited case. I would say also that a proper expedited case requires an effective cooperation between the parties and the arbitrator. I see as well that many times the parties are not as sophisticated. You sometimes have ex-party cases or cases where one party acts pro se, and that requires a great deal of pedagogy from the arbitrator and the institution, so that the arbitrator has to be willing to dedicate that time to educate the parties on expedited cases. And also for that same reason, they have to be available on such a streamlined process and context, and it's not always the case. So those are the caveats. It is a very useful tool, a very efficient resource, but it has to be used wisely. I don't think I have any additional comments on our expedited cases.
Thank you, Anya. That was really clear, and I would just like to contrast the institutional procedures with ad hoc environment. Maybe, Steven, you can briefly cover this part, and then we get back to the questions from our audience.
I have a few comments. There generally weren't rules on non-administered on expedited arbitration in ad hoc. CPR has rules on global rules on accelerated commercial arbitration. They've been around since 2009. I think they probably work pretty well. UNCITRAL has now published expedited rules starting, those rules went into effect last year, 2023. I think, though, that to contrast it is, if you really want a case to be done quickly, you're going to have you're going to have arbitrator selection be much more difficult in an ad hoc case than with Anna giving you 5 names and to only strike 2. And I want to just talk a little bit about a successful expedited arbitration, and I was the arbitrator and Anna was the case manager. And even in that case, the claim for $400 million, but the clause said expedited rules. Even in that case, with all of Anna's talents, one of the parties was really able to delay the appointment of the tribunal, throwing in all kinds of objections to proceeding and going forward. Eventually, Anna got through that with them. And just to kind of give you an idea of how it can work, I was invited to serve in late April. I made my disclosures in a day or two, and the next day I was confirmed in mid-May. We had the case management conference in late May. We had the first round of submissions in the middle of June. We had the second rounds of submissions in early July. We had the hearing, a 2-day hearing in mid-July. We had post-hearing submissions in mid-August. And we had an award before September 15th, which was within the 30 days of the last submission. So the whole thing went from late April to mid-September. It was a complicated case. They didn't get $400 million, but they did get a substantial award. And the parties did not get along that well. They were pretty nasty, but it needs a strong arbitrator to keep it moving, and that's my story.
If I may, I must say that to his credit, not all arbitrators are like Steven Skulnik, I must say, and it was a tough case.
Okay, you're too kind. Thank you.
Thank you both. I would like to turn to the questions from the audience. We have really good questions. The first one is, how do emergency arbitrators balance their speedy review and due process issues? I don't know, maybe Michael, you can start on this.
Yeah, look, I think how much process is due is sort of an American judicial response. How much process is due depends on the circumstance, right? There's not sort of there certainly are some minimal irreducible elements, like both parties have to have an opportunity to address whatever the issues are, but it's nowhere written that sort of due process necessarily requires certainly full American style discovery, or even more limitedly, the more complicated or actually simpler disclosure process of the normal rules. As long as both sides are treated equally, both sides are given an opportunity to participate, and the arbitrators have drawn to their attention any kind of specific problematic asymmetry in information and deal with it, I think the basic standards of due process are met. So I think that one can have a 24-hour process that's due process. And more than that, I remind everyone that, I'm a common lawyer. I think of due process that way. In the civil tradition, there's the notion of it's really for the decider to figure out what evidence they need, not for the parties to develop the case. And certainly that no one would contend that the civil law denies due process.
If I may, I fully agree with Mike. I think it depends on the circumstances, and that the arbitrator hears the parties and provides enough opportunities for them to present their case. But they also need to have, a strong control of the time limits and of the proceedings, because what should be avoided is, especially in the responding party trying to delay the emergency arbitration proceedings. So sometimes there will be a non-happy party, but provided that everything is on the record and that the basic rules were follow, I think it's fine. And you also have, or we have had emergency arbitrator proceedings with non-participating responding parties because they just chose not to participate. But then the proceedings have to get going.
Thank you both.
I would add, since we're talking about emergency arbitrators, you have to give the parties a full opportunity to make their submissions, but it has to be in a timetable that you will get your reward out within the 14 days. And that is not unique to arbitration. Parties who are seeking provisional remedies in U.S. courts or courts around the world are used to having short timetables to put their submissions in. And so, there's nothing really different about arbitration in that respect. When it's an emergency, things have to move quickly.
Yeah, thank you. I have another question directly for Paul. Do emergency awards go through the same ICC court review process? And how long does the process typically take? Also, if urgency is not addressed in the draft award, is it something that ICC court requests in the emergency awards to amend?
Yes, so as to the first question, no, the draft order is not subject to the scrutiny process, and that's why it's not called an award, because all awards under the rules before being issued, they have to go through this review process, which takes some time. We do perform what we call a informal scrutiny, so we do touch base throughout the proceedings with the arbitrators and make sure that he or she will share with us the draft order just to provide. And it works more or less like a scrutiny process. There are several people involved, but the comments are basically bubble comments or in a draft email, and there's no approval. So basically, these are the comments. Please feel free to consider them. If there are any red flags, perhaps we would, convene a call, or we would ask if we could see the updated draft. But we try definitely not to delay the issuance of the order because of this. And as to the second question, yes, if the urgency, as I mentioned earlier in my presentation, if the element of urgency is not analyzed both as a substantive and also as an admissibility requirement, this is the sort of comments that we informally convey to the arbitrator.
Thank you, Paul. I have an institutional question. So in the event if tribunal has been constituted, but then it becomes invalid for some time, for example, due to reassignment or party challenging the members, to whom should the parties turn for interim or conservatory measures? Can it be an emergency arbitrator? Anna, would you like to answer this one?
Well, I mean, the question is complex, but yeah, every time you don't have a full panel constitute, you should have to be able to resort to an emergency arbitrator if there's something to be decided on an emergency basis. What I've seen, not necessarily that, but what I've seen is that a party files for an application for emergency arbitration, it is granted or not, we appoint the emergency arbitrator, the whole case goes on, we have an interim award. Meanwhile, the main case goes on. I'm in the process of appointing the tribunal, but the parties are asking for extension. They don't get to an agreement as to whether or not to use the list. There's some challenges going on. It's taking more than expected to have a full panel or the arbitrator ultimately appointed. And something comes up. And then again, one party has to file for an emergency request. And in those cases, what I've done is either I ask the emergency arbitrator to serve once again as emergency arbitrator for the second request, or to appoint a new emergency arbitrator. If it happened while once that I had a tribunal empaneled and something happens, and for some, temporarily I'm out of a full panel, I will consider to appoint an emergency arbitrator. I would need to see the specifics because, maybe a decision can be rendered by majority of the tribunal already constituted. It depends on the circumstances, why this arbitrator is no longer there. Why do I not have a full panel at this point? But I think it is an instrument we should be able to use every time it is needed, because the main thing is that if you don't have a full tribunal functional in place, then you have to resort to this alternative mechanism for a decision to be rendered to preserve the status quo.
Thank you, Anna. I think I have just one last question, so we can end on time. How do arbitral institutions decide whether to issue an award or an order? Because as we heard, award is easier to enforce under the New York Convention. So I don't know, Steven, maybe, or Michael, would you like to share your thoughts?
Well, so look, Steve is free to add, but I would say two things. One, sometimes the rules say, so as Paul has pointed out, the ICC rules say in the ICC context, what the arbitrator does is called an order. It is not called and so if the arbitral rules have a circumstance, and you certainly would never call it a final award, it might be a partial award. And frankly, I would be open to the parties pointing out to me what Steve talked about earlier, which is if it relates to the enforceability of the jurisdiction, his example of Atlanta versus New York, I might style my decision in a way that would promote its enforceability. Steve, have I left anything out?
No, but generally it's an order, and generally either it's gonna be enforced or not enforced, regardless of what you call it.
But can you somehow influence the arbitrator's will and ask specifically for an award?
Who
Can you-
influence the, that's the arbitrator or his counsel?
The counsel, the petitioner. Can they
The
ask?
counsel says it's very important to me, just as
Yeah.
Mike said, to call this an award, because in my jurisdiction in Louisiana, they apply the Napoleonic Code, and it has to be an award. Fine, but I don't really care. But it really should. And now if the other side objects and says no, and then they have to brief it.
Okay, thank you. And I'm not sure if you have enough time, maybe just a view from Anna and Paul, what's the state at your institutions?
Now, very briefly on my end, as I said, under the rule, it's called an order, because awards under our rules have a different process. But again, based on my experience, I have never seen an issue of enforcement or compliance of these orders. Also, bear in mind, as I mentioned, the truth is that most of them are rejected, like over 50%. And I think, and I checked our statistics, only 14-15% of the orders of the relief is granted in full. And in those situations, the rule is voluntary compliance.
I would just wanted to add, Article 7.4 provides for either order or interim award in the ICDR rule. So it is up for the arbitrators to decide. If I was to deny the request, I wouldn't have any problem in granting an order, issuing an order. If there's going to be something that may be subject to enforcement, I might consider to reframe it as an interim award. If I was the arbitrator, I'm not.
Thank you. Well, I think we are out of time. We have some more questions, and we have really nice audience and amazing questions. So thank you, first of all, very much for our esteemed speakers. Thank you, everyone, for joining and sharing your knowledge with our audience. Thank you, our attendees, for asking really great questions. It was a really enjoyable discussion, and it will be recorded and uploaded to the Stanford Law School YouTube channel. So thank you very much, and have a lovely day.
Thanks, Andrii, for inviting us. Bye,
Thank you very
everyone.
much.
Thank you, Andrii, for moderating.
Thanks.
Thank you.
Bye all. Thank you.